So hello everyone. Uh, it's 9:30. I hope a lot of people will join, but if not, I'm going to go ahead and get started. So we're going to be reviewing Chapter 7 today, and I'm going to be talking about strict liability and product liability. So let's see. What are those two? There's some key differences that you should know. Well, strict liability means liability without proving fault. No ifs, ands, or buts about it. You don't need to prove negligence, only that the activity or product caused harm. It commonly applies to abnormally dangerous activities like skydiving, for example, wild animals, or defective products. So, what are the abnormally dangerous activities? Let's define them. These are activities involving a high risk of serious harm that cannot be eliminated even with reasonable care. So, some examples of these are explosives, toxic chemicals. Yeah, that's all I got. If harm occurs, the defendant is liable, even if they were careful. For example, that circus. Let's just say a lion got loose from the circus and ran away, and suddenly they scratched someone or bit someone or something. Who's liable? Well, it's the circus manager, the circus, more specifically. So, owners of wild animals, as I was saying, are also strictly liable for injuries caused by those animals. Next, let's go into product liability. What's product liability? Liability basically holds manufacturers and sellers responsible for harmful or defective products. It can be based on four things. As Ms. Singh said, it can be based on one, which is negligence, two, misrepresentation, three, strict liability, and four, warranty. So the most tested theory is going to be strict product liability. Next up, let's go into negligence in product cases. So, what does negligence mean really? Negligence means failure to exercise reasonable care. Manufacturers must use due care when designing, selecting materials, manufacturing, testing, inspecting, and adding adequate warnings. No privity of contract is required. Don't worry, I'll define it in a second. The plaintiff must prove cause in fact and proximate cause. These are terms from Chapter 6. So, what is misrepresentation? Well, basically, if a manufacturer knowingly lies about a product, that's fraud. The plaintiff must show false statement of material fact, knowledge of falsity, intent to induce reliance, and actual reliance, and most importantly, damages. So, an example of this is intentionally false labeling. So, let's just say you have M&Ms, right? And then they're peanut M&Ms. Someone's allergic to them, but you want to make a quick buck, so you don't label it as peanut M&Ms. So, yeah. And next, let's get into strict product liability requirements. So, to win under strict product liability, the plaintiff must prove six things. If one of the things fail, then it's not going to be strict product liability. So, number one, the product was defective when sold. The seller is in business of selling that product. The product was unreasonably dangerous. There was physical harm that occurred. The defect was the proximate cause. And lastly, the product was not substantially changed. There is no need to prove negligence, only defect and causation. So, next we have what is unreasonably dangerous? Let's quickly define that. A product is unreasonably dangerous if it is more dangerous than an ordinary consumer would expect, or a safer alternative design was available. Next, let's get into the three types of product defects. Number one is a manufacturing defect. This happens when the product deviates from design specifications. Number two, we have a design defect. The design itself is unsafe. And then number three, we have inadequate warnings. So basically, failure to warn about foreseeable dangers or misuse. Like, for example, for a child, that would be like warning it as a choking hazard, like a toy or something. There is no duty to warn about obvious dangers. Next, let's move into number nine, which is who can be liable. So, strict product liability can apply to manufacturers, sellers, distributors, component suppliers, injured bystanders. Next, we talked about like a lot of the not the defense side of things, right? So let's talk about defense now. So, common defenses would include preemption, which is federal law overrides. So, like if, for example, a pharmaceutical company knows that a drug has side effects and things like that of that sort, then they would get it tested, do everything, and then run it to the FDA. If FDA stamps it, then that's basically like the federal government saying that it's safe, and that's called preemption. Next, we have assumption of risk. Then we have product misuse, comparative negligence, commonly known dangers, and a knowledgeable user. These are the common defenses. And we're almost there. So, next we have the statute of limitations. What is this? Product liability claims must usually be filed within 2 to 4 years, depending on state law. And then strict liability shifts focus away from fault and toward consumer protection. If a product is defective and unreasonably dangerous, manufacturers and sellers can be held liable even without negligence. And that's chapter 7 in a nutshell. I hope you had a great review. I know I did. And I'll see you next time. I hope you had a great night and bye.